Excellencies, honorable delegate, distinguished participants, dear brothers and sisters, dear colleagues and friends, good morning, good afternoon, good evening to everyone. It is again a pleasure to be here today and to continue our discussions on trade, investment, and development in Africa. So yesterday, you remember that we started with the investment part of this week session, and I started with a first issue, which is the traditional, what we can call the traditional landscape of investment law in Africa. And I showed you how the investment regime could be traced back to the end of the 18th century, and how at the beginning there was some disagreements or maybe even some clashes, confrontations between developed countries and developing countries on whether international law should be applicable to the treatment and protection of foreign investment. I showed you how the US and France were convinced that under customary international law, such a treatment and protection of foreign investment should be given, should be granted by states. And I showed you how there was some resistance, and maybe one of the most famous resistance came from Latin America and in particular Argentina with the famous Calvo doctrine. But then I told you that after the second half, from the second half of the 20th century, so after 1945, the battle was no longer about whether or not international law can be applicable to the treatment and protection of foreign investment. The battle was more about which standards, what should be the standards, what should be the content of the standards, substantive standards, procedural standards. The battle shifted there. But then I showed you that Africa, in the context of that battle, Africa was in a paradox, or in a paradoxical posture. Why? Because yes, Africa joined other developing countries in the early 1960s after many of our countries gained independence, acceded to independence. Africa joined many developing countries, in the battle for the new international economic order that was taking place in the UN, and we fought that battle, and you remember that one of the most important outcome of that battle for the new international economic order was the adoption in 1962 of the famous UN General Assembly Resolution 1803 on permanent sovereignty over natural resources. Permanent sovereignty over natural resources, that a nation, a people never loses its sovereignty over its natural resources. So we joined that battle. And that battle, as I told you, was not just a battle for the new international economic order, but it was also a contestation of some of the investment standards that developed states were pushing for, that developed states was pushing for. So, for instance, one standard that we were contesting as developing countries in during the battle for the new international during the battle for the new international economic order, one standard we were contesting as developing countries was what we call the Hull formula. Hull is Hull. So Hull was the name of a U.S. Secretary of State in the 1930s, who during a battle with Mexico, during a diplomatic battle with Mexico, told the Mexican government that when a state expropriates or nationalizes foreign property, that states needs to pay prompt, adequate, and effective compensation. That's what Hull said to his Mexican counterpart in the 1930s. That in case of expropriation, so when a state takes the property of a foreigner or nationalize the property of a foreigner, Hull told his Mexican counterpart back then in the 1930s that that state under customary international law has the obligation to pay prompt, adequate, and effective compensation. That's what we call the Hull formula. Well, when we launched the battle, when African countries and other developing countries launched the battle for the new international economic order, they rejected the whole formula. They rejected the whole formula. If you look at some of the most important resolutions that have been adopted by the UN General Assembly during um, the battle for the new international economic order, for instance, Resolution 1803 on permanent sovereignty over natural resources, or the resolution entitled, the resolution of 1974, entitled Charter for the Economic Rights and Duties of States. If you look at those resolutions, you would see that we said that in case of expropriation, appropriate compensation should be paid. Appropriate. Appropriate. So we rejected the whole formula. So this is what Africa did by joining the battle for the new international economic order. We joined a battle where we were basically saying we do not agree, we do not subscribe to the investment standard as shaped, as formulated by Western countries, by capital exporting countries. That's what we did. But then, that's what I call the paradoxical posture, the paradox that I described yesterday. But then, while we were doing this battle with the African countries in the early 60s, so remember the very first bilateral investment treaty, the very first BIT, was concluded between Germany and Pakistan. But then I told you that during the 1960s, the countries that were the most proactive in the negotiations and conclusion of bilateral investment treaties were the African countries. And by concluding those bilateral investment treaties, we subscribe to the standards that we were rejecting in the UN. We subscribe to them because then those capital exporting countries, they made us sign bilateral investment treaties that would, for instance, repeat the whole formula. That would repeat the whole formula. In case of expropriation, prompt, adequate, and effective compensation. They made us sign bilateral investment treaties where at some point there was consent to arbitration. There was consent to investment arbitration, to go to arbitration. While in the battle for the new international economic order, we were contesting the right for a foreign investor to have its dispute being settled by international arbitral tribunals, by internationalized dispute settlement mechanism. We were saying it should go before the domestic courts. There's a need to exhaust local remedies to have the domestic courts settling the disputes and not international arbitral tribunals. So this is why I described yesterday what our countries have done in the 60s, 70s as a moment of paradox, but then I describe it also as a moment that we can call the bilateralization of the investment regime, meaning every single African country going on its side and negotiating bilateral investment treaties with capital exporting countries. So there was not yet a collective vision in the 60s, in the 70s, in the 80s, and I would say almost till the end of the 1990s. There was not a collective vision when it comes to investment in Africa, except maybe some very exceptional circumstances where African countries were part of other regional organizations, and they because of that they were engaged in collective efforts in regulating foreign investment in those regions. One example is, of course, the OIC, the 1981 OIC Investment Agreement. The OIC is the Organization of Islamic Cooperation, the Organization of Islamic Cooperation. The Organization of Islamic Cooperation had a regional investment agreement already in 1981. And because almost half of the membership of the OIC is composed of African countries, you can say that yes, some few African countries have been engaged in collective effort, but it was not a collective intra-African effort. It was not a collective intra-African effort. It was a collective extra-African effort because those efforts were made in the context of other organization. Also, this is why I insisted yesterday to say that in a first moment, what we witnessed in the traditional investment law landscape in Africa was a bilateralization. But then let me now continue. Let me now continue because then, of course, after the bilateralization, what we witness is what you see now here in the screen, an expansion, of the investment regime in Africa. That's where we stopped yesterday. The expansion of the investment regime in Africa. What do I mean by the expansion? Well, starting from a certain moment, in the 1980s, 1990s, during that critical period of time, investment law in Africa wouldn't just be regulated by bilateral investment treaties. We started to witness what I call the expansion. The expansion means first national investment laws. National investment laws in Africa, more and more and more countries in Africa adopting national investment laws. That is something we we started to witness more and more, more and more. It was not that all African countries in the 1980s or 1990s, all of them adopted national investment laws. But progressively, in the 1980s, 1990s, it was the moment where we could witness an increase in the adoption of national investment laws in the continent, within the continent. Some of the first national investment laws were already present in the 1970s. If you take a country like Egypt, in the 1970s, Egypt had already an investment law that was applicable, which actually gave rise to one of the first known investment arbitration against an African country. It was based on that national investment law of Egypt of the 1970s. But the critical moment where we started to witness an expansion, so an increase in the conclusion of in the adoption of national investment laws was mostly between the 1980s and the 1990s. So this is one aspect of what we can call the expansion of the investment regime in Africa. When you deal with investment law in Africa, you cannot just think that only BITs are applicable. Yes, bilateral investment treaties are there, but there has been a complexification of the regime. There has been a densification of the regime. There have been what I call an expansion of the regime. And so you have national investment laws that are applicable in almost every single African country. Then, second aspect of the expansion, the exponential conclusion of investment contracts. Investment contracts. This is another phenomenon that we've been witnessing more and more in Africa, in particular from the 1990s. African countries concluding more and more investment contracts. So what is an investment contract? An investment contract, don't confuse it with an investment agreement. Don't confuse it with an investment agreement. An investment contract is an agreement, yes, but it's an agreement between a private entity, so a foreign investor or a foreign investment company, and a state. So if you have Microsoft coming to invest, for instance, in Libya, and Microsoft concluding an agreement with Libya to regulate the investment, this is an investment contract. It's called an investment contract because you have the presence of a private entity. You have the presence of a non-state actor, which is Microsoft. So this is what you call investment contracts. So these investment contracts, one of their particularity in Africa is that they are quite often opaque. They are quite often opaque. What do I mean that they are quite often opaque? Is that most of the time, they are not made public. They are not made available to the public, and that's one of the main characteristics of these investment contracts in the continent is that it's not always clear what is there. But one clause, that is quite often incorporated in these investment contracts that are not good clauses for our countries. That are not good clauses for our countries. I need to insist on that. And one of those clauses is what we call the stabilization clause. The stabilization clause. The stabilization clause. What is a stabilization clause? A stabilization clause is a contractual clause in which a government is saying to a foreign investor, well, you know what? If I adopt new legislation in the future that is less favorable, than the legislation that was applicable to you at the time you came to invest, that new legislation won't be applicable to you. That new legislation won't be opposable to you. Yeah. So basically, the stabilization clause freezes. It freezes the regulatory power of our countries. It freezes the regulatory power of our countries, the right to regulate of our countries. Because you tell a foreign investor, well, you know, if you came in 1995 and you had the right to pollute, if I adopt a new legislation in 2012 where you no longer have the right to pollute, then that new legislation that says you don't have the right to pollute because it's less favorable to your business won't be applicable to you. This is problematic. This is problematic for countries that are pursuing the welfare of their people. They should have the right to have progressive regulations, progressive legislation. 30 years ago, no one was paying attention, for instance, to global warming. Today, all our countries are paying attention to global warming because Africa is the most vulnerable continent to the adverse effects of global warming. So what does it mean? It means that today our government would have to regulate in order to deal with the global warming, to fight global warming, to fight the adverse effects. And regulating in relation to climate change may entail new obligations, new constraints on foreign investors and their investments. But if you put a stabilization clause, if you incorporate a stabilization clause in your investment contracts, you are basically, preserving, protecting the investor, the foreign investor, and his or her investments from any from the applicability of any new progressive regulation or legislation that is there for, again, once again, that is there for the welfare of the people. So this is one thing we find quite often, one clause that we find quite often in the investment contracts concluded by African countries, but which is really problematic. And one recommendation, because we are here talking among Africans, one recommendation is to be careful not to systematically incorporate this type of clauses in the investment contracts that we are concluding. Another, last but not least, aspect of the expansion of the investment regime in Africa is the multiplication of what we call international investment agreements in Africa, IIAs. This is another, I would say, another aspect of the expansion of the investment regime in Africa that we are witnessing in the continent, and AFCFTA is part of it. I'll come back to that. The investment protocol to the AFCFTA is part of this phenomenon of expansion. But what we've been witnessing in Africa since the 2000s, no? So national investment laws, they started to increase in the 1980s, 1990s. Investment contract in the 1990s, late 1980s, early 1990s. Multiplication of international investment agreements in Africa is a phenomenon that we started to witness mostly in the 2000s. No? More and more IIAs. Also, whenever you see that acronym IIAs, it means International Investment Agreements. So more and more IIAs being concluded. So what do I mean by the IIAs? So the IIAs is actually the expression that is used by UNCTAD. No? If you look at the text of UNCTAD, you will see that UNCTAD uses the word IIAs to refer to that constellation of international investment treaties. No, that's in IIAs. It refers to international investment treaties. You see, they are different from investment contracts. Why? Because these IIAs, they are investment agreement that are concluded between states, between African states. They are concluded between African states, and that's why we call them IIAs. So the IIAs, what are there in Africa? First, what do we mean by the multiplication of IIAs? Well, exponential conclusion of BITs. Exponential conclusion of BITs. More and more African countries concluding bilateral investment treaties. More and more African countries concluding bilateral investment treaties. This is one aspect of the multiplication of IAs in Africa. There presently we have something like 2,500, 2,600 bilateral investment treaties that have been concluded since 1959. Since 1959. Among those 2,500, 2,600 BITs that have been concluded, more than 800, more than 800 have been concluded with an African country. Yes, more than 800 have been concluded with an African country. So what does it tell you? It tells you that almost one third of the bilateral investment treaties that have been concluded in the history of international investment law have been concluded at least with one African country. So you see that this is something we've been witnessing, that exponential conclusion of bilateral investment treaties in the continent, and it is continuing. It is continuing. There are some states in Africa that have stopped negotiating bilateral investment treaties. For instance, South Africa. South Africa is among the countries in Africa that is no longer negotiating any bilateral investment treaties. But majority of African countries are still negotiating bilateral investment treaties. So we are not at all in an era where African countries have stopped negotiating bilateral investment treaties, despite the criticism, despite the criticism that is quite often characterizing these bilateral investment treaties. And I come back to that. I'll come back to the criticism in few minutes. But African countries are still very much engaged in the negotiations and conclusion of bilateral investment treaties. Where there has been an evolution, is on the partners. The partners. Traditionally, if you take the bilateral investment treaties that our countries have concluded between the 1960s and the 1980s, I would say even early 1990s, if you take the bilateral investment treaties concluded in the 60s, 70s, and 80s by African countries, it was bilateral investment treaties concluded with what I would call global North countries. So the traditional capital exporting countries coming from the Western world. So BITs with European countries, France, Germany, Netherlands, Italy, Sweden, Belgium and Luxembourg, Spain. So with the traditional capital exporting countries. In the 1990s, we started with US, with Canada. So this is what we were mostly witnessing in the 60s, 70s, 80s, and till a certain point in the 90s. From the 90s, and then it became even more frequent in the 2000s, the bilateral investment treaties that we would conclude would be more South-South BITs. We used to conclude North-South BITs. Now we are more engaged in the negotiations and conclusions of South-South BITs. So bilateral investment treaties with China, bilateral investment treaties with India, bilateral investment treaties with some countries, some other countries in Asia or in Latin America, in the Middle East. In the Middle East, you know that today many of the Middle East countries have become very important capital exporting countries. Saudi Arabia, United Arab Emirates, Jordan, Kuwait, Qatar, they have become very important uh, in terms of foreign direct investment. So we've been witnessing that, what I would call this change in the physiognomy of bilateral investment treaties, that our countries are negotiating more and more South-South BITs. And of course, South-South BITs mean also more and more intra-African BITs. Intra-African BITs. Many intra-African bilateral investment treaties. So BITs concluded between African states. This is part of that exponential conclusion of BITs that is reflecting what I call the multiplication of international investment agreements in Africa. Second aspect of the multiplication of international investment agreements in Africa, well, again, the spaghetti ball. The spaghetti ball. You remember when we were talking about the regional economic communities, I used that metaphor of the spaghetti ball of the regional economic communities. Well, the regional economic communities, they have been also vehicles, vehicles of investment law. Because yes, because many of the treaties that are establishing the regional economic communities would contain investment provisions or an investment chapter or investment chapter. That's what we call investment chapter of free trade agreements. The free trade agreements, the agreements establishing our regional economic communities or other free trade areas in Africa, you would find that in those treaties, you would find provisions or chapters on investment. But you would also find chapters, investment chapters, in the free trade agreements that African countries conclude with non-African countries, with other nations, or in the economic partnership agreements, the EPAs, the economic partnerships that we would conclude, for instance, with EU, with the European Union. You would find there provisions, chapter, a specific chapter on investment. So you see that you cannot just tell yourself that the investment regime that is applicable in Africa is limited. Even in terms of treaties, you cannot say that it is limited to to bilateral investment treaties. You need also to take into account all those investment chapters of free trade agreements, all those investment chapters of economic partnership, agreements. And you see, an investment chapter of a free trade agreement or of an economic partnership agreement, an investment chapter may look like a BIT because you find the same standards, the same rules, but it's not a BIT. It's not a BIT because the bilateral investment treaty, first of all, is concluded only between two states. Only between two states. The free trade agreement or the economic partnership agreement is not necessarily concluded only between two states. Actually, in Africa, most of the time it's concluded between more than two states. So you cannot say that it's a BIT, it's not bilateral. But also, a free trade agreement is not an investment treaty. A free trade agreement is mostly dealing with free trade. So with trade, and then in the context of that free trade agreement, you have an investment on chapter. You have a chapter on investment. So you cannot call it a bilateral investment treaty because the bilateral investment treaty not only is bilateral, but it is only dealing with investment. It's a treaty dedicated only and only to investment, period, to the protection, promotion, encouragement, reciprocal encouragement of investment. So you cannot call it, you cannot call the investment chapter of an FTA or of an EPA a BIT, even if the content is quite often similar. Another layer, another layer of the multiplication of IAs in Africa, and I would call it even an African exception, an African exception, an African particularity. The increase, the increase of regional and continental investment agreements, what I like to call RIAs, regional investment agreements, increase of regional and continental investment agreements in Africa. Yeah, yes. This is an African exception. We are the continent that has the biggest number of regional investment agreements. I'll come back to that later on when we continue. I will show you how our regional economic communities have been laboratories, have been fora for the development of regional investment law. And that's why yesterday when we were having the conversation, I was telling you, dear brothers and sisters, when you assess the work of the regional economic communities, you cannot just talk about trade liberalization. You cannot just look at trade liberalization because they've been doing more than that. They were maybe not as efficient with trade liberalization, but they've been very good with other things. And one thing that they've done well is the regionalization of investment law, creating regional legal frameworks for regulating investment, the flows of investment in a given region. And Africa is even pioneer because we are the first and only continent till today that has a continental investment agreement, a continental one. So an investment agreement that is applicable at the level of the entire continent. That's the investment protocol to the AFCFTA that we will discuss tomorrow for the last course tomorrow. I will put an emphasis on the investment protocol to the AFCFTA. I know that some of you have already starting asking questions about the investment protocol to the AFCFTA and what is the dream of making Africa an investment destination under the AFCFTA investment protocol. Don't worry, I'll come to it tomorrow. That will be the closing. I will come to it tomorrow. Don't worry about that. I need first to show you where we're coming from, and how things evolved. Because at the end of the day, again, AFCFTA, you cannot understand it if you don't look at it from the context of what has been the economic integration in Africa. And one major aspect of the progressive development of economic integration in the continent has been the increase of regional and continental investment agreements. Yeah. And we are the only continent with with an investment treaty applicable to the level of the entire continent. So that is another layer that is very important. Last but not least, this one is a question mark. This one is a question mark for reflection in the future, particularly for those of you who are reflecting on research, which topic to research on for your articles, your publications, or your master thesis or your PhDs or whatever scientific research. This is like reflection. Should we in Africa, should we push for the development of sectorial investment agreements? So African sectorial investment agreements. What do I mean by sectorial investment agreement? Sectorial investment agreement are those investment agreements that are dealing with a specific sector of investment, a very specific sector of investment. And we know in Africa, for instance, that mining is a very specific sector of investment that is creating a lot of trouble to African countries. Many trouble with foreign investors. Many trouble, many cases. Just look at the recent wave of cases against African countries before exit. By the way, I was asked by a francophone colleague, what is CIRDI? CIRDI in French. CIRDI c'est le Centre international de règlement des différends d'investissement. ICSID is the English version, International Center for the Settlement of Investment Disputes. In French, it's CIRDI, Centre international pour le règlement des différends d'investissement, qui est basé à Washington, D.C., qui est une organisation qui est membre, sorry, now I'm speaking French, sorry, which is based in Washington, D.C. The ICSID is based in Washington, D.C., and it's one of the organizations that is member of the World Bank Group. That is a member of the World Bank Group. And it is today the most important, the most proactive institution when it comes to investment arbitration. But look at the wave, at the recent wave of investment cases, investment arbitration cases filed against African countries. Many of them relates to mining. Oil and gas. These are very important sector of investments. Agriculture. So the question, very important question, that is a forward-looking question, is what should we do in Africa? Should we have our African sectorial investment agreements? So for instance, Europe has its own energy charter treaty. Yeah, they have. They have a sectorial investment agreement called the Energy Charter Treaty of 1993. Energy Charter Treaty. That was an sectorial investment agreement concluded between Western Europe, countries from Western Europe, Central Europe, Eastern Europe, plus Russia. Today, you have many countries that are withdrawing from it. But Europe has been coming with its vision of how to regulate investments in the field of energy. So what about us? What about us? Shouldn't we consider, and that's why I'm telling you, this is a very nice article maybe to publish, to research on, what could be the gains, the prospects for Africa to actually develop its own sectorial investment agreements. So we have a common African vision when it comes to investments in the mining sector, a common African vision when it comes to investment in the agricultural sector, a common African vision when it comes to investment in the field of oil and gas. Why not? That's why I put a question mark. Okay? But this is what I wanted to tell you about the expansion of the investment regime in Africa. So you see that the landscape is very complex. The landscape is very complex. I would even say that the landscape is fragmented. Yeah, the landscape is fragmented. If you look at what I'm showing you now, the landscape is fragmented because you have all these layers. National investment laws, investment contracts, IIAs, and in IIAs you have BITs, investment chapters, regional. So at the level of every single African country, of almost, not all African countries, but almost every single African country, you have all these layers of investment regulations that are applicable. So the landscape is fragmented. And when the landscape is fragmented, it doesn't help to attract FDI. And remember I told you yesterday, we need FDI. We need foreign direct investment for our development. We need it. There's no doubt. But when the legal landscape is fragmented, it's very hard to create favorable investment climate. For investors, they go where you have a favorable investment climate. I know that someone asked me that question yesterday. In foreign investors, they go where there is a foreign, when there is a favorable, where there is a favorable investment climate. And one sine qua non, one condition for a favorable investment climate is to have coherence in the landscape, in the legal landscape, in the regulatory framework. But in Africa, the problem we have is a problem of fragmentation of the investment law landscape because of all these layers, because of this expansion I'm showing you. And you know, you know, there are two major factors, if you allow me very quickly, for me, because I think it's important also to speak about the reality of what is happening in our countries. There are, in my view, two factors, two sociological or administrative, call them like as you want, sociological or administrative or political factors that explain the fragmentation in or the lack of coherence in our countries. The first problem is the problem of coordination within our countries. Coordination. Yes. Internal coordination. Those, you would find out that in every single African country, those who are in charge of enacting national investment laws are not the same than those who negotiate investment contracts, who are not the same than those who negotiate BITs, who are not the same than those who negotiate free trade agreements, who are not the same than those who negotiate regional or continental investment agreements. They are not the same. But it's one thing that they are not even the same. The problem is that these people don't coordinate. In many countries, you have this lack of coordination. They don't coordinate. They don't talk to each other. Sometimes they are not even aware of what is being done by another ministerial department or by another agency. And this is what leads to the fragmentation. That you negotiate a BIT as an African country, you negotiate a BIT in which you are accepting standards that are contrary to what you have in your national investment law, and vice versa. So coordination is fundamental. And we go to many African countries, we support many African countries, we support them on how to put in place effective mechanisms of intergovernmental coordination when it comes to investment lawmaking. Otherwise, we cannot create favorable investment climate. So the issue is institutional. You need the integration, the integration, sorry, the coordination. There's a second factor. There's a second sociological or political factor that explains the lack of coherence, the lack of consistency, the fragmentation. The second factor, the second problem, is the continuity issue. The continuity issue. In many of our countries, one problem we have is that, there is no continuity when it comes to those who are in charge of economic negotiations. Economic negotiations, including investment negotiations. There's no continuity. Whenever you have a new government or a new minister, you have a change of teams. In many countries, not in all. Not in all. There are some very good practices. There are some very, very excellent models in the continent. You take certain countries in the continent, they are very good in having continuity in their teams. And you can see in those countries, you can see that the level of incoherence, of inconsistency in investment lawmaking is much lower than in countries where there is no continuity, where there is constantly change in the teams of those who are negotiating or who are in charge of economic negotiations. So we need to solve that. We need to solve the coordination issue. We need to solve the continuity issue. Economic negotiations, they have to be as how do you say that? They have to be as sustainable as possible. Meaning they have to be part of a continuum. They have to be part of a continuum. And even if the teams are changed, we need to make sure that the institutional memory is there. That if you have someone new, that the new person is at least assisted, supported by someone who was there for the last 10 years and who knows what is the institutional memory of the state when it comes to investment negotiations, when it comes to investment law. So this is a reality. These are reality factors that I'm sharing with you. But because once again, we are not here just to talk about the law, we are also here to talk about what is preventing the law from being effective, what is preventing the law from being efficient, what is preventing the law from providing to our countries positive outcomes. Coordination is a problem. Continuity is a problem when it comes to the investment law landscape. Okay? Allow me now to come to another aspect still of the traditional landscape. I told you about the era of bilateralization, then how we went to expansion and fragmentation. But now I need to focus a bit on, okay, but what are the common features, in particular, of the international investment agreements that we have been concluding in Africa? Because as I showed you, there has been multiplication of international investment agreements. And since we are going to talk about AFCFTA, which is an international investment agreement, the AFCFTA investment protocol, since it is an investment agreement, we need to ask ourselves first, yeah, but what have been the common features of the traditional dominant model of IAs concluded in Africa? We need to look at that. First feature, focus on investment protection. Focus on investment protection. Yes, this has been really a feature of the of the dominant model of IAs that our countries have concluded. And there Africa is not alone. Most developing countries, when they concluded BITs, they subscribe to a model focused on investment protection. So Africa is not the only one. Because most of us developing countries, we've been subscribing to models coming from capital exporting countries, in particular in the West. And what is the major concern of those capital exporting countries? To make sure that their citizens, when they go to a country, in Africa, for instance, that they benefit from maximum protection. From maximum protection. So that's why that dominant model of international investment agreements has been focusing solely on investment, protection. Even if sometimes the title would say, even if sometimes the title would say, agreement on the promotion and protection of foreign investment, or agreement on the reciprocal encouragement of promotion of foreign investment. This would just be in the title. In the title, you would see the word promotion, you would see the word reciprocal encouragement, but in reality, these agreements, they've been focusing only and only and only on investment protection. You know, those who know me here, I know I have some people here. Those who know me, they know that usually I like to provoke and say that in every family, there's always a spoiled child. Even if the parents don't want to admit it, there's always a spoiled child. I like to provoke. I say it to provoke and to joke, that there's always a spoiled child, even if the parents do not want to admit it. And I always like to joke and say that the spoiled child of the international law family is the foreign investor. He's the foreign investor. Yeah, yes. Why? Why? Because when you look at the BITs in particular that we've been concluding from the 1960s till the early 2000, you would only see rights, 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 and rights for the foreign investors. Right to non-discrimination, right to fair and equitable treatment, right to full protection and security, right to compensation, right to arbitration, rights, rights, rights. Only rights. States, only obligations, no rights. Where did you see treaties like that? For those of you who are familiar with treaties, it doesn't work like that normally. In treaties, you have rights and obligations for states, but not only obligations. Not only obligations. So this has been, you see, the dominant feature of the BITs that we have been concluding. So yesterday someone asked me, "Oh, did BIT contribute to attractiveness of investment?" Well, it's not me talking. It's not me talking. It's not me talking. It's UNCTAD talking. It's World Bank talking. It's OECD talking. Many organizations talking, saying, look, there's no objective study that can prove you the correlation between concluding a BIT and the increase of investment flows on the territory of a state. So we African countries, we concluded 1/3 of the BITs in the history, but then we only attract 4 to 5% of the global flows of FDI. So the BIT is not a magic stick. It's not because you conclude a BIT and up, you get the investors coming. Investors, they need a favorable investment climate first and foremost. The BIT can help, can support, but it's a broader agenda that you need to attract foreign investors and to retain them in your territory. Not just concluding a BIT. But many of our countries, they got into the BIT wave because they were told, it's not the fault of our countries. They did it in good faith. They were told that if you conclude BITs, focus on investment protection, you will attract foreign investment. We are still waiting to see. So you see, this focus on investment protection can be problematic. I'm not saying that protection should not be granted, but the focus on it can be problematic. Rights can be problematic. And I'm smiling because few months ago, I was going to be appointed in an investment arbitration case by an African country, and the lawyers of the investor said that they would challenge me because they saw a video of me in a class where I was saying that the foreign investors are the spoiled children of the international law family. Well, you know what? I'm repeating it here today again. I'm repeating it because I think that in an academic context, we should be able to say what we think. It doesn't mean that we are against foreign investment. I've been telling you we need actually foreign direct investment. I've been insisting to say we need FDI. But which type of FDI do we need for Africa? So they can challenge me if they want. But I would say it because that's what we have to say. That's what we have to say. It's good to give rights, but what about the rights of our countries? What about the rights of our people? So I hope they watch again this video. Second common feature of international investment of the dominant model of IAs that our nations have concluded. The second feature, broad standards of investment protection and treatment. That's another feature. If you want again to understand tomorrow what's coming with the investment protocol, you need to understand where we're coming from and what the investment protocol to the AFCFTA is trying to fix, is trying to change, is trying to shift. One problem that we've been having are the broad standards of investment protection and treatment in our BITs in particular. You know, I'm sure that many of you here have already read a BIT concluded by your country or another country, or have been even negotiating, because I know that we have diplomats here attending that maybe you've been even negotiating BITs. But if you know the traditional length of a bilateral investment treaty is maybe three to 5 pages. 3 to 5 pages. 3 to 5 pages. I even always like to provoke and to say that in investment law is actually not that hard to study, because you have what, five, six, seven standards. When you compare that to law of the sea, to humanitarian law, to international criminal law, to the law of treaties, seven standards, 7 to 8 standards is not that big, believe me. What makes investment law complicated is the case law. Is the case law, because there's a lot of case law going in different direction. That's what makes it maybe very hard to study, because then you have to read all these case law to figure out what are the right interpretation, or what are the interpretation adopted by investment tribunals. But when you look again at the standards, we talk about 7 standards, 8 standards that are formulated in a very broad manner. So our countries would conclude BIT in which they would say, oh, I take the commitment to grant national treatment, period. I will not treat the investors of this other country less favorably than my investors, period. I take the commitment to grant FET, fair and equitable treatment, period. If I had the time to ask to every one of you what is FET, we would have 400 different interpretations of what it is. FET, full protection and security, period. That is a problem. This has been problematic. Why? Because basically, as a government, you are considering that you leave it to some external arbitrators one day to decide what is the meaning of what you have concluded in a treaty. You negotiate, but then you leave it to someone that you don't know one day, sitting in a tribunal, decide what you meant by putting FET, fair and equitable treatment, in your BIT. So you don't have any control on whether the standard would be interpreted in a manner that is compatible with the concerns, the interest, and the developmental needs of African countries. Yeah, that's another feature. Third feature. Third feature. Very important common feature. Broad offer to arbitrate. the broad offer to arbitrate, yeah. This has been one of the main feature of the BITs in particular that our countries have been concluding. Broad offer to arbitrate. Yeah. I should have even put broad blind offer to arbitrate. Why do I say broad blind offer to arbitrate? Because if you look at the physiognomy of the BIT that we have been concluding, you will see that our countries would just say, okay, you know, you conclude a BIT with I don't know, with Canada, and you put a provision where you say, well, if the Canadian investors have a problem with me, they can bring me to arbitration. ICSID, Permanent Court of Arbitration, International Chamber of Commerce, London Court of International Arbitration, they can bring me to international arbitration the day they have a problem. So you don't know who's going to use it one day. because it's a blind offer. You just put in the treaty. If a Canadian investor has a problem with me, they can take me to arbitration. You don't know who's going to use it one day against you. But this broad offer to arbitrate is an offer that is made to the foreign investor. So what does it mean? It means that the investor can trigger arbitration against the state, but the state cannot trigger arbitration against the investor. Do you see what offer means? Normally consent to dispute settlement in the international legal system, consent is normally reciprocal. State A can file a case against state B, and state B can file a case against state A. It's reciprocal. But here what we have is not reciprocal. The offer is made to the investor, meaning that arbitration can only be triggered automatically by the foreign investor, not the reverse. In most of the cases, not of the reverse, because of how we shape the provision, or how we shape what we call ISDS. ISDS, whenever you see the acronym ISDS, it means investor state dispute settlement. ISDS, it means investor state dispute settlement. So the way we shape ISDS means the investor can attack the state. That's why it's called investor state. It's not called state investor dispute settlement, but investor state dispute settlement. In French, RDIE, le règlement des différents investisseurs États. RDIE, the investor against the state. But it may happen situations where the state would like to be the one complaining against the investor. Why wouldn't we consider that arbitration could also be triggered by the state? Why not? The idea is not to say, again, the idea is not to say, let's not grant protection. The idea is not to say, let's not have standards of protection. The idea is not to say, let's not have arbitration. I'm not yet there. The idea is to say, how do we make all this? How do we make all this compatible with the needs of African countries? That's where the debate is. It's not about being against, because again, we need FDI. We need it. And to get FDI, you need to protect it, like it or not. Access to justice is good. No one is against access to justice. At least me, I'm not against access to justice. But which type of access to justice are we talking about? Which type of justice are we talking about? How is it compatible with the needs, the concerns, the problems of African countries? That's where you need to think. That's where we need more publications, more thinking, more reflection to bring a real African view on that. Let me now finish with the future. Why is there a need to reform? With what's coming for the next session and next tomorrow. Why is there a need to reform? I showed you the common features, and now we need to ask ourselves, well, why is there a need to reform the traditional investment landscape? I showed you the traditional investment landscape. So why do we need to reform it? Why do we need to reform it? Because AFCFTA investment protocol, as we will see tomorrow, the AFCFTA investment protocol is a tool. Is a tool of reform. It is a tool of reform. So the question is why? Why is there a need to reform? And that's what I like to call where Africa joins the global. Where Africa joins the global. What do I mean by this little subtitle? where Africa joins the global. I'm insisting on this little subtitle to emphasize that today the need to reform the investment regime is not just an African narrative. It's a global narrative. It's not just an African narrative. It's not just a global South narrative. It is a global narrative. Everyone in the world, 99% of the states in the world, agree that there's a need to reform the investment regime. So it's not an African narrative. We were the first ones. I will show you. I will show you that we were the first ones who started to do it. We were the first ones who started to do it. And back then, when we were doing it, we were called activists. Now everyone agrees that we need to get there. So why? Let me get to the why. First reason why we need to reform, and you saw it already. Asymmetry. The asymmetry of IIAs. Asymmetry of IIAs, in particular bits. I see you. I said it already. I said it already. You saw it already because I told you, look, in BITs, investor only has rights, states only obligations. That is the asymmetry. That's the asymmetry. So we need to solve the asymmetry. We need to solve the asymmetry. We need to think about rights for investors, but we need also to think about rights for states. Yeah. We need to think about obligations for states. Yes. But we need also to think about obligations for investors. You need to correct the asymmetry. That's the first reason why we need to reform. Second reason why we need to reform, regulatory chill. The regulatory chill. The traditional dominant model of IIAs has led to what we call regulatory chill. The traditional dominant model of IIAs has led to what we call regulatory chill. Regulatory chill. What is the regulatory chill? The regulatory chill is when investors invoke BITs to prevent a state from regulating. We've been seeing cases where a state, for instance, wanted to adopt a new environmental legislation or a new tobacco legislation or a new public health legislation, and the state would be threatened by a foreign investor, telling the state, if you move ahead with your new environmental legislation, or if you move ahead with your new public health legislation, I will initiate arbitration against you. And in many cases, states have backed down. Yeah. In many cases, states have backed down. I've said, no, let me not regulate. Let me not adopt a new climate legislation because I don't want to go to arbitration. Because arbitration means lawyers to pay, arbitrators to pay, means reputational damage for a country. Yeah. So this is what we have been witnessing. That these investment agreements, the dominant model, de facto has led to some regulatory chill. States hesitating to adopt legislation for the welfare of their people because of the threat of arbitration. Is it normal? I'm just asking you. Or the regulatory chill also comes from very broad interpretations of the broad investment standards that prevent states from regulating. Ask yourself, is it normal? Is it why nations are concluding treaties? Is it why nations are concluding treaties? Is it what international law is about? Preventing state from regulating? Ask yourself that existential question. Third reason why Third reason, and I was just mentioning it now, expensive, expansive, expansive, not expensive. They're also expensive. Interpretation. They're also expensive when you get condemned, but expansive, expansive interpretations by investment tribunals. Expansive. Yeah. Like very elastic, very elastic, very, very large interpretation of the standards. Yeah. Because the standards are so vague, as I told you, as I've shown you in the dominant model, because the standards are so vague, so broad, then one of the consequences has been that some investment tribunals have engaged into very broad interpretation, expensive interpretations, which most of the time are not going in the direction of states, which most of the time are not are not in the interest of states, or are not compatible with state sovereignty, are not compatible with the right to regulate of states. Some tribunal, for instance, would tell you, oh, FET means the legitimate expectations of foreign investors. That when you are a foreign investor, you come to a country, you have some legitimate expectations. You come to Africa, you have legitimate expectations that there will be sun all the time. The day there's no more sun, there's a violation of FET. I'm provoking, of course. But it's just to show you what are the legitimate expectations. This is a very elastic, far-fetched concept. What about the legitimate expectations of states? What about the legitimate expectations of states? Another why. Why do we need to reform? Inconsistent interpretation by investment tribunals. Inconsistent interpretations by investment tribunals. Yeah. Because the dominant model is built upon very broad standards, vague standards, then it allows different tribunals to come with different interpretations. So there's no legal predictability. There's no legal security. There's no legal coherence. How do you want, again, to create favorable investment climate if the law is subject to inconsistent interpretations? Depending on who's sitting in a tribunal, you would come with a different interpretation of FET or a different interpretation of the scope of the most favored nation treatment clause. It's problematic. But because, let's not blame the tribunals. I try to be as balanced as possible in what I say. Let's not always say, oh, it's all that is because of the tribunals. The tribunals, they are here to do what? They are here to apply the law. If the law is not well done, then the interpretation of the law won't be well done. It's as simple as that. It's too easy to always say, oh, the tribunals are the bad guys. The arbitrators are the bad guys. Some maybe, but it's too easy to just put everyone in the same basket and say, oh, the arbitral tribunals are not good. Arbitration is not good. No. Any international dispute settlement mechanism, in particular those that are of a judicial nature, like arbitral tribunals, they are here to apply the law. To apply the law. So if the law that they have to apply is not well shaped, then you would have very, very bad interpretation of the law. That's it. So it is for us to think about the right investment law to enact, to formulate, and to shape. And then last but not least, and this brings me to the next part of the session. Last but not least, why is there a need to reform? Well, lack of integration of sustainable development goals, lack of integration of sustainable development goals, of SDGs, of sustainable development in the dominant model of IIAs. Dear brothers and sisters, we concluded these IIAs to do what? To increase development, to ensure development, to facilitate sustainable development, to foster sustainable development among within our countries. But how do you want an agreement to contribute to your development if that agreement never mentions development? I'm asking you, how do you want an agreement to contribute to your development if the agreement never talks about development? Is not articulated around development, is not shaped around development, does not contain developmental features, developmental objectives, developmental considerations. How do you want that agreement to contribute to the development of African countries? Let's be rational. You cannot hear me saying this and then say that I'm against foreign investors, or that's not, it's not about that. It's about being true in what we are talking about. If these agreements are here for development, then they need to talk about development. But you cannot sell me that an agreement that doesn't talk about development is here for the development of African countries. This is a problem. And this is why we need to reform. And everyone agrees that we need to reform and make sure that the new generation of investment agreements contain sustainable development goals, sustainable development objectives. Thank you for your attention. Allow me now to continue a bit and start the next session, if you allow me, so we can already get closer to tomorrow. Huh? I want now to continue after having talked talked about the traditional investment landscape in Africa and the problem it is causing, for you to know why we need to do something else now in the continent. Allow me now to come to what I call the early approaches. The early approaches to the reform of the investment regime in Africa. The early approaches to the reform of the investment regime in Africa. It's very important. The reason why I want to do this part very briefly, this part of the session, is to show you that actually we African countries, we didn't wait. We didn't wait. We didn't wait for the world, for the global world to say, let's reform, to start reforming. Actually, Africa has been pioneer in reforming. Since the early 2000s, our governments, and this is very important because, again, I think it's not fair that we always focus only on what has not worked well and what has not been done well by our countries. Let's also talk about the things they have done well. Yes, you can criticize many of the BITs that our countries have concluded. Yes, and I've done it. But then we were the first one to wake up. In the early 2000s, we were the first ones in Africa saying, look, there's a problem with the way this investment regime is being done. And we're the first one who came up with innovative approaches on how to reform the investment regime. So for almost 40 years, Africa was a consumer of rules, of investment rules coming from elsewhere. But then we started to become rule makers. investment rules makers. So we went from rules takers to being rules makers in the field of the investment regime. And that's what I call the early approaches. Because the AFCFTA investment protocol that we will discuss tomorrow is the last one, the most recent. But the early approaches, look at this. I don't want to insist, but I just want to give you a tour d'horizon. The reform in Africa started in 2006 when SADC adopted its protocol on trade and investment. That was 2006. No one at that time at the universal level was talking about reforming the investment regime. Not even UNCTAD, the United Nations Conference on Trade and Development. UNCTAD is maybe around 2011, 2012 that they adopted the investment policy framework for sustainable development. That started to talk about, sustainable investment. But 2006, SADC came with the SADC Protocol on Trade and Investment. And SADC was pioneer. Why? Because look, the SADC Protocol came and emphasized corporate responsibility. Corporate responsibility. Something that you couldn't find in the traditional BITs, that I'm a traditional dominant model of BITs. SADC came and talked about corporate responsibility. That investment has to be investment of quality in the continent. That the investment that deserve protection should be an investor that is, or an investment that is oriented toward corporate responsibility. Respect for the laws, regulations, guidelines, policies of the African state. Look at as example, Article 12 of the protocol, of the SADC protocol. It emphasized the need to protect the natural resources in a sustainable and environmental friendly manner. Something you are not finding in the dominant model of BITs. So you see how we started step by step in Africa with the SADC protocol of 2006. We started to emphasize the need to have a more developmental approach to investment regulation. How we emphasize the need that investment, foreign direct investment, should be here to contribute to the development of our countries. A development of quality at the health level, at the environmental level, at all levels. You see? Look, environmental measures. State parties recognize that it is not appropriate to encourage investment by relaxing domestic health, safety, or environmental measures just to attract investment. No. Attracting investment should not lead a state to relax its domestic health, safety, or environmental measures. We innovated. We innovated with this, with the applicability of the principle of non-regression in the field of investment. Right to regulate. Right to regulate. The SADC protocol on trade and investment is maybe the very first one in the history of international investment law that explicitly focus on the right to regulate. That a state has the right to regulate investments in its territory in a manner that is sensitive to health, safety or environmental concern of that state. Look how we open the gate of international investment law. How we made sure that we started to send a message that investment law is not just about investment. That investment law is about a broader developmental agenda. It started in 2006. Then it continued. Then the SADC launched a trend, that became a continuous trend in Africa. 2007, COMESA, the Common Market of Eastern and Southern Africa, adopted the very first, regional investment agreement in Africa. So the very first investment agreement regulating investment in a regional economic community, in an entire, just on investment. Because SADC was trade and investment. This one was just investment. This one also continued the trend. Look, Article 13, entitled Investor Obligation. Investor obligation. This is pioneer. That the investor should not just have rights, but it should also have, or she should also have, obligations. Investor obligation. That was the title of Article 13. You see? Then it continued. 2008, what you have here is the Supplementary Act of ECOWAS. So you see the trend, how it became constant in many parts of the continent. If you talk about SADC, if you talk about COMESA, if you talk about ECOWAS, you talk about 3/4 of the continent. 2008, look, ECOWAS came and talked about obligations and duties of investors and investments. General obligations, all that, you will have it with you, so you can look at them at home when you have time. We will make sure to provide you all these slides. They are here for you. Obligation and duties of investors and investments. Look at this. Re-establishment impact assessment. That was never seen before, dear brothers and sisters. Never seen before in the history of international investment lawmaking. ECOWAS came and say, investors and their investment, they must conduct an environmental and social impact assessment on the potential investment. Sorry. They must conduct an environmental and social impact assessment of the potential investment. I don't have time to read all this. You will read it at home. This was pioneer, active, made by Africans in Africa for Africa. Look, post-establishment obligations. Look at the paragraph 2 of Article 14. Investors shall uphold human rights in the workplace and the community in which they are located. So you see that many of the problems we are talking about, talking about today, we were already thinking about legal solutions a long time ago. So it's wrong to think that nothing was done in terms of law. Maybe there has been problem of implementation. Maybe there have been problem of coordination. Maybe there have been problem of continuity. Maybe there have been problem of capacity building. Yes. But we've been doing it. And we didn't wait any universal trend to do it. The 2012 SADC model template, that was another big turning point. Why it was a turning point? Because starting with this 2012 SADC model, in Africa, the message became that now what we want in Africa is sustainable investment. Sustainable investment. That what we want to regulate is sustainable investment. That was the turning point. That is not just about investment, but sustainable investment. That was a new era. 2012 SADC. And if you read the preamble, it's all about connecting investment to sustainable development, recognizing the important contribution investment can make to the sustainable development of the state parties. Next paragraph, seeking to promote, encourage, and increase investment opportunities that enhance sustainable development. Look at this. Yeah, that's what I call the turning point. And this turning point, and I will conclude on this, this turning point is what led to the new continental vision. So you see that the continental vision is a result of the initiatives, the efforts that have been put in place by regional economic communities when it comes to reforming investment law. And that's when, in 2012, after the adoption of the SADC model, that's why I call it a turning point, that's when the African Union said, okay, now we need to go for a Pan-African vision. A Pan-African vision, we need to negotiate a Pan-African investment code. This is what paved the way to what we know today with the investment protocol. I'll tell you more stories tomorrow. Stay tuned. Thank you so much. Have a great day. Thank you. Great afternoon, great morning, great evening. Thank you very much. Thank you. Thank you.
Thank you. Thank you so much, Makane, for that wonderful lecture today. Uh, and the very interesting proposal for sectoral investment agreements, which I believe has great merit.
No, that's excellent. No, that's excellent. And thank you, Virginia. I can testify because I've been knowing you now for almost 20 years, and I can testify of all the great things you've been doing for the continent, all the dedication, even when you were in the UN, how you were the one behind, boosting the all regional courses in international law. So you are a true believer in education, in international law dissemination, and we can never thank you enough. I think I told you that several times, and that's why when you call us, we cannot also say no to you, no matter how busy we are, no matter how as stressed we are, we have to do it because what you do is what our continent needs, and it's so great that you are the one who came with this vision. So thank you, and of course, you can always count on me if and
Yeah.
I'm so proud to see that so many people are also, engaged and are here. It shows the determination, and it shows also the mindset of the present and future generations of African lawyers. This is just amazing to see so many people here, and I'm sure many will also watch. So really congratulations to you and to everyone. And we will continue. We will continue, and whatever knowledge we can share, we will come and share it. Thank you.
It would be a far greater challenge if people didn't care. If this generation of law students and lawyers, if they didn't believe in the Pan-African vision, if they didn't care about learning about African Union law, that would be a problem. The problem we have is truly wonderful because so many people want to learn about it.